All right, so this is what the court is going to do. The court is going to set the bond at $130,000, full GPS, waive fees, no contact with minors.
And the $5,000 that you said that you could come up with, is that when, are you taking into consideration other things, or is that just based on the sale of your home?
That's based on the sale of the home, and after I pay off what I need to make sure my other children are.
847, State of Texas versus John Anthony Ayala. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Alex Scharf for the defense.
And are you John Ayala?
Yes.
All right, we're here. The state has, the defense has filed a motion seeking a bond reduction. State, have you had a chance to review the state defense's motion, and are you ready?
Yes, Your Honor, we are.
All right, defense is your motion.
Thank you, Judge. Call Yvette Ayala as a witness.
All right, Ms. Ayala. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you state your name for the record.
Yvette Ayala.
All right, defense.
Thank you, Your Honor. Ms. Ayala, where do you live?
151 Bangor.
In San Antonio?
Yes.
All right. And are you working?
Yes, sir.
Okay. Where do you work?
Commercial kitchen, parts and service.
Okay. You married?
No.
Okay. And John is your son, is that correct?
Yes.
How old is he?
19.
19. He has no criminal record, is that correct?
No, sir.
Now, you know that he's charged with a continuous sexual abuse for minors, is that correct?
Yes.
All right. And that the bond is currently set at $150,000. Is that correct?
That's what it is.
Okay. Now, do you have $15,000 to pay to a bondsman or to someone to get him out on that high of a bond?
No, sir.
All right. Is there anything, property that you own or that you can, is there an amount that you can get together of money that you could put towards a bond to help to get John out of jail?
I'm currently trying to sell my house.
Okay.
With the money that I get back, though, I'm trying to make sure I get my other kids set up. And I don't have any more vacation time to take, so when I have doctor's appointments and stuff for here, I have to take an unpaid day off. So, but crunching the numbers and everything, I mean, I can do like 5,000.
All right. And in the event that the bond is reduced or you're ever able to make it, where will John be living?
With my grandmother.
Okay. Are there any minors under 17 that live there?
No. Not that I'm aware of.
Is that your mom?
No, it's my grandma. My mom's another option as well.
Okay. There are places where he can live
Yes.
that would not violate any conditions.
Yes.
Okay. Pass the witness.
Just a few questions. Ms. Ayala, you said you owned your own home?
Oh, I'm still paying for it, but yes.
You have a mortgage on your home? Okay. And the $5,000 that you said that you could come up with, is that when, are you taking into consideration other things, or is that just based on the sale of your home?
That's based on the sale of the home, and after I pay off what I need to make sure my other children are labeled. I need a place for them to live.
If you were going to sell your home, where are you going to live?
Our plan right now is to sell our home, get an apartment, I would like to pay it for a year, because like I said, with my hours not meeting, I don't want to stress over eviction.
So the 5,000 you're considering is in part due to you want to prepay a year your rent. As far as if he were to make bond, regardless of the amount, you said that he was not going to be residing with you.
No, because I have my daughter.
And how old is your daughter?
I have my 16-year-old and my 12-year-old.
Okay, so you have two children under the age of 17.
I have 3. My youngest, my son is 11.
You have 11, 12, and 16. Did I understand that correctly? And they would be residing with you. I'll pass the research.
Any further questions?
Nothing further, Judge.
All right,
Pass
John,
witness.
Are you next witness?
We rest.
All right, State.
Yes, Your Honor. At this time, say we just offer state exhibit number 1, which has been previously tendered to defense.
No objection.
All right, then State's exhibit number 1 is admitted into evidence. Just give me a moment to read it. All right, the court will hear argument. Defense, it's your motion.
Thank you, Judge. After reading the exhibit that the state tendered to you, I believe that most of the allegations happened or are alleged to have happened when Mr. Ayala was a juvenile. To take that into consideration, that might have an effect on the jurisdiction of the case. 19 years old, no priors, has a safe place to stay. I understand the seriousness of the charge. But $150,000 bond, I mean, I've seen murder cases with less than that. Stabbing, shootings, all that kind of stuff. I would ask that you reduce the bond from $150,000 to $50,000.
All right, State.
Yes, Your Honor. I guess 2 things from the state's perspective. Number 1 is just the offense in and of itself, which the court is well aware of, and the seriousness of these allegations, and the defendant's own admission to committing these offenses. The court's well aware that juveniles go to prison as well for these types of offenses. So the fact that he was a juvenile doesn't negate the age difference in this case, which I believe is, if I'm calculating it correctly, would be at least a 9-year difference between the 2 individuals. Secondly, in determining what is the appropriate amount to set in this case, obviously the court's taking into consideration the ability for the defendant to make bond. And so in this case, I don't believe that Ms. Ayala has demonstrated through, or the defense through Ms. Ayala has demonstrated the inability to pay, rather the inconvenience of being able to pay. She has other understandable uses and needs for that money, but prepaying a whole year of your rent, even assuming rent is $1,000 a month, that's $12,000 right there. And that's including, talking about her having to have at least 3 kids, and that would be pretty relatively safe to expect that'd be $12,000 right there. And so it's not the most convenient way for her to use her money, but obviously I don't think that should be taken into play what the court is going to consider. And so we're asking that the bond, the writ be denied, that the bond is already appropriately set at an amount based on the nature of the offense, the specific allegations of this offense, and the lack of evidence to show that the defendant has the inability to make the bond as presently set.
Defense, it's your motion, so you have final argument.
Thank you, Judge. Ms. Ayala, told the court she doesn't have the money. She's in the process of selling her house. God knows when that will happen. Or how much it'll be. But clearly she doesn't have the money to make this bond right now. She's justified to that under oath. When and if the house gets sold, depending on what it gets sold for and all that. Her son is still in jail. And he's been there for over a month, and it's his first offense, and he's been throwing up all morning. He spit out. And we think that realistic just bond can be formulated. I believe full house arrest has already been ordered as a condition of his bond, where you can lower the bond to $50,000 and protect and give protection to the community, to the alleged victim. And so we're gonna say that we did show that she cannot make the bond right now at this moment.
All right, so this is what the court is going to do. The court is going to set the bond at $130,000, full GPS, waive fees, no contact with minors.
Thank you, Judge.
All right, are we ready?
State is calling 2023 CR 7220, State of Texas versus Ricky Perez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Christopher Simpkins for the defense.
And are you Ricky Perez?
I am, Your Honor.
All right, in defense, can you pronounce your name again, please?
Ricky Pettis.
No, defense, can you pronounce your name again for the record?
Christopher Simpkins.
All right, thank you. And the reason why I asked, I'm reading the court reporter's record, and I think you said it too quickly. All right. Counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Pettis, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, I did. Yes, I did.
Counsel, do you waive the reading of the indictment?
Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Pettis, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did. Yes, I did.
Did you understand you're charged with the offense of theft under $2,500 enhanced? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, I do.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
I understand that.
Did you understand by entering this plea, you were giving up those rights?
I understand.
Did you intend to give up those rights and enter into a plea in this case?
I do, Judge.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and was.
Mr. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Absolutely.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir. Yes, I do understand.
According to the plea, punishment is to be assessed at 102 days in the Bexar County Jail under 1244. There are no applications. State will take in consideration 2023 CR 7219, And nightmare number 734-805. Did you understand that to be the plea?
Yes,
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
There are not, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to present?
Your Honor, I offer State's Exhibit 1 and the attachments.
Any objections?
No objections, Your Honor.
State, you may continue to confer.
Thank you, Judge.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
That's correct. Yes, Your Honor.
I'm sorry, in all appropriate places.
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentence?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I believe he has 102 days credit in Bexar County Jail. We just ask that you follow the plea bargain and satisfy the judgment.
All right. Court will find you guilty, sentence you to 102 days under Bexar County Jail, in the Bexar County Jail on 1244. Take in consideration 2023 CR 7219, NIMAC number 734-805, and there's to be no contact with any HEB. You're gonna have to find some other place to shop. You understand?
Yes, yes, Your Honor.
Gonna show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Perez, I see that you went to the pastry portion of HEB and just started taking things that don't belong to you. You're not allowed to steal. I don't care if you're hungry. If you haven't had any foods, you're not allowed to steal. It's better to ask, hey, I don't have any money. HEB does do charity work. There's the Salvation Army. There's the food bank. There are plenty of places to go if you want something to eat other than stealing. You understand?
I do.
All right, good luck to you. 2
In the
days
state of
the
Texas
Bexar County
versus
Jail.
John Anthony Ayala, the
1244.
defense filed a
There are
motion
no
to reduce the
applications.
19-year-old
State will take in
defendant's bond from
consideration
$150,000 to
2023
$50,000.
And NIMAC number
Ayala, who has no prior
734-805.
criminal record,
Did you
faces
understand that to
charges
be
of
the plea?
continuous sexual
Yes.
abuse of a
Defense, is
minor.
that the plea?
Yes, Your Honor.
The
State, is
defense
that the
argued
plea?
that the
Yes, Your
current
Show
amount
you
was
the waiver of
excessively
appeal
high,
paragraph.
noting that
Review
some
that
violent
paragraph
crime
with your
cases
attorney.
carry lower
Did you
bonds.
understand it?
They
And
also
did you sign it in
emphasized
both
that the
places?
alleged
Yes,
offenses
Your Honor.
mostly
Did you
occurred
understand
when
by
Ayala
signing
was a
that you're waiving
juvenile,
your right
which
to
could
appeal?
affect
The only
jurisdiction.
items that can be appealed
To
are
demonstrate
written pretrial
safety,
motions
the
that have been
defense
filed,
stated
heard,
that
and
full
ruled
house
upon by
arrest
the
had
court.
already
Did you
been
understand?
ordered,
Yes,
and
Your Honor.
Ayala would
Counsel,
reside
are
with
there
his
any such
grandmother,
motions?
There are not, Your
completely
Then to the
separated from any
offense as charged,
minors.
how do you plead? Guilty,
The
not
defendant's
guilty,
mother,
or no
Yvette Ayala,
contest?
testified
contest.
about her financial
State, any
constraints.
evidence to present?
She
Your Honor, I
explained she
offer
was
State's
selling her
Exhibit
home to
1
move
and
her
the
other 3
attachments.
minor children
Any
into an
objections?
No
apartment.
objections, Your Honor.
State, you
After
may continue
factoring
to
in these
confer.
relocation costs
Showing you
and her
what's
plan to
entitled
prepay a full year of rent
waiver
to
and
secure
consent
her
to
family's
stipulation of
housing,
testimony
she
and
stated she could
stipulations.
only afford
Did you
to
review that
contribute
with your attorney? Did you
$5,000 toward a
understand it? Did you
bondsman.
sign it in both places?
The
That's correct, yes,
prosecution
Your Honor.
strongly
I'm
opposed
sorry,
the
in all
reduction,
appropriate places.
highlighting the severity
ma'am.
of the
Again,
allegations,
did you
the
understand you have a
defendant's
right to
alleged
jury trial,
admissions,
right for you
and
or
an
your attorney
approximate
to
9-year age
cross-examine and
gap
confront
between
any
Ayala and the
witnesses,
victim.
state would call in the right
The
to
state
remain
also
silent.
argued that the mother's ability to prepay a
Did you
year of rent,
understand that today the
totaling an
state would be
estimated
presenting
$12,000,
evidence in the form
proved
of
that paying the
witnesses'
bond was a
statements and
matter of
police
financial
reports, but
inconvenience
most
rather than a
importantly,
true
there would be
inability
no
to
live
pay.
testimony. Did you
After
understand?
hearing both
Yes, Your Honor.
sides, the judge rejected the
Court will
defense's
find that
request
the
for a
defendant has knowingly
$50,000
and
bond.
voluntarily waived and consented to
Instead, the
stipulation
court
of
compromised
testimony
with
and
a minor
stipulations. Court will
reduction,
accept
setting the
into
new
evidence
bond
states
amount at
exhibits running attachments and review the
$130,000.
same.
The reduction was paired with strict conditions, including mandatory full GPS monitoring with waived fees and a strict order allowing no contact with minors.